Tonight, Member of Parliament for North Dai attempts to put a final nail in the coffin of the controversy surrounding legal education in the country as he moves to file a private member's bill to, among other things, redefine the functions of the General Legal Council and remove the CJ and all other justices of the Supreme Court from the Council. This comes just hours after the AG rejected a resolution of Parliament to admit the 499 students.
The agencies may not come to us directly, but the Attorney General is answerable to Parliament, and it may be called to Parliament to explain why the resolution cannot be respected.
We have details as the former director of the Ghana School of Law backs the AG's position.
It is a discretion that Parliament cannot question. I'm afraid I cannot go along with Parliament in this unnecessary directive that they have given.
And Top Story is brought to you by Vodafone. Together we can. My name is Ernest Mino. Tonight, the rift between the executive and the legislature over admissions into the Ghana School of Law has taken another dimension. In the last few minutes or hours, the Member of Parliament for North Dai, Roxanne Dafiameto, has served notice of his intention to sponsor a private member's bill to amend the Legal Professions Act 1960, Act 32, to, among other things, redefine the functions of the General Legal Council and remove the Chief Justice as well as other justices of the Supreme Court from the Council. Now, this is coming just hours after the Attorney General rejected a resolution by Parliament to admit the 499 students who insist they passed the professional law school exam but denied admission. First, listen to the Deputy Speaker of Parliament, Joe Osei-Owusu, who read out what the House resolved.
All in favor of the motion, say aye. Aye. All against the motion, say no. The ayes have it. The motion is adopted. The Ghana General Legal Council is hereby directed to proceed and admit all the students who pass in accordance with the advertised rules of the examination. Under the General Legal Council Act, the Attorney General is the minister responsible, and the law says that he may give general directions. I hereby direct that the Attorney General shall ensure that this resolution is carried through. Thank you.
Well, that is the Deputy Speaker of Parliament, Joe Osei-Owusu, but the Attorney General says that resolution is not backed by law. My colleague Kweku Asante joins me with excerpts of the AG's response to Parliament. Kweku, to the specific response of the Attorney General to the directive of Parliament, what does it say?
Right. According to Attorney General Godfred Yeboah Dame, and I'm quoting from his letter to the Speaker of Parliament, he says, whilst recognizing the general legislative powers of Parliament in Ghana, except as has been circumscribed by the Constitution, I'm constrained to advise Parliament is devoid of a power through the use of parliamentary resolutions to control the process of admission into the Ghana School of Law. The mode of exercising legislative power enshrined in Article 106 of the Constitution does not admit resolutions. In accordance with Sections 13(1)(e) and F of the Legal Professions Act 1960, Act 32, the power to regulate the admission of students to pursue courses of instruction leading to qualification as lawyers and to hold examinations, which may include preliminary, intermediate, and final exams, has been vested in the General Legal Council. And he quotes the law and continues to say that it is actually the President who may direct the Attorney General in this respect, and he says that the President has already directed him to do something of the sort.
Thank you very much. That's my colleague Kweku Asante bringing us details of that response of the Attorney General to the to Parliament on its directive to admit the 499 students. But the first Deputy Speaker of Parliament, Joe Osei-Owusu, insists the General Legal Council is, quote, amenable to the oversight of Parliament. In an interview with my colleague Emefa Pau, he warned that the AG will be hauled before Parliament to answer why the directive cannot be respected. Listen.
Well, I think it is clear. This was a resolution of Parliament adopted, directed at the General Legal Council that they should go by the advertised procedure for determining pass or fail. And by that, we suggested that the 499 or so who had obtained the 50% mark or more should be admitted. I hear people say that Parliament is giving instructions to the judiciary. Let me make it clear that the General Legal Council is not part of the judiciary. The General Legal Council is an executive agency created by Parliament. The Attorney General is the minister who has ministerial responsibility. To that extent, the General Legal Council is amenable to the oversight of Parliament. And that's what we're seeking to do. Parliament did not instruct them to do anything. Parliament did not order them to change or make any new rules. All we said was that we saw the advert they made in the newspaper. We know by practice they determine they have 50% mark. And indeed, the acting director, when the current director was on leave, the person who acted, Mr. Ukajima, is that right? Yeah. He said on air that when they put that advert, they intended or they meant 50% or more. That's all Parliament is saying, that please follow what you have done in the past and let those who have obtained 50% or more get access to the school.
Well, for some, at least, for some legal experts that we've heard on this matter, it's more like tantamount to Parliament giving orders to the executive, because looking at the Legal Professional Act 5, for instance, the council shall in the performance of their functions comply with any general directions given to them by the minister. So orders to the executive is the question I'm asking.
No, we knew all the time that the General Legal Council would be is the Attorney General, who is the minister, who can answer for the actions or inaction of the General Legal Council. So after we adopted the resolution, the consequential order was that the Attorney General shall ensure that the General Legal Council complies with the resolution, the orders containing the resolution.
Are you hopeful that this will actually have any legal effects? The GLC will actually comply with this particular order from Parliament?
I have no reason to believe that they will not. If Parliament, the representative of the people, the agency that created, the arm of government or the institution that created the agency, that imbued it with all the powers, cannot ask them to follow the rules they make, at least the Attorney General is answerable to Parliament. The agencies may not come to us directly, but the Attorney General is answerable to Parliament, and it may be called to Parliament to explain why the resolution cannot be respected.
So that is the firm position of Parliament on this issue. We'll be speaking to the Member of Parliament for Sadai, Roxin Dafiametpo, shortly. But just this afternoon, a former director of the Ghana School of Law, Kweku Ansah-Sarr, waded into this controversy. He says Parliament's resolution is unnecessary, a red herring, and an attempt to create a false expectation among the 499 students. He spoke on the Pulse with my colleague Aisha Ibrahim.
As far as I'm concerned, the directive by the Speaker is without any legal basis. And if it is implemented, it will amount to a limited interpretation of the functions of the General Legal Council. That's my first reaction. Secondly, nowhere in the Constitution has it been expressly stated that Parliament can intervene in such matters. Thirdly, the Legal Professions Act in section 1 subsection 5 states clearly that it is the council, that is the General Legal Council, that shall serve in the performance of their functions, comply with any general direction given to them by the minister. My understanding of minister in at 32 is that the minister refers to the minister that the president shall assign certain functions to handle. Parliament is not a minister, and therefore Parliament should not wade into this unnecessary legal banter with anybody. I'm surprised that Parliament, will take upon itself something, to throw a red herring into the eyes of the general public. General Legal Council is the only statutory body responsible for the administration of legal education in Ghana. No other body. Even that the council conducts the entrance exam comes under LI 2355. And again, it provides that the Ghana School of Law may grant admission to an applicant to undertake the professional law course if the applicant has passed an entrance examination organized by the council, not an entrance examination organized by Parliament. So the Parliament doesn't come in. Again, LI 2355 states that a person is not qualified for admission to undertake the professional law course where that person is for any justifiable reason considered by the council to be unsuitable for admission. It is a discretion that Parliament cannot question, and Parliament can flex its muscles and pass you. I'm sorry, Parliament can't do that. They simply don't have the power. They should be encouraged to study harder and pass next time, rather than what Parliament is trying to do. Parliament is creating a very false expectation in them. It is not legitimate.
The latest in this controversial issue is that the Member of Parliament for Southern, Roxanne Dafiametla, wants to address these lingering issues of legal education through a private member's bill. He joins us live on the line. Mr. Dafiametla, thank you very much for your time here on Top Story. So clarify for me, what you have filed is a memo to the Clerk of Parliament informing him of your intentions to sponsor a private member's bill, right?
Indeed, yes, but that is just procedural. But first of all, let me say good evening to your listeners, as well as my constituents who have been disappointed and on whose behalf I'm waging this war, who want to just enter law school and become lawyers like me. First of all, the memo is also sponsored by my brother Susu. We have procedurally written to the clerk to direct the legislative drafting office to put together a bill for this purpose. But what has actually been done is that I have worked on the bill myself. You prepared the memo, the amendments that we intend to bring to bear on the Parent Act have all been done. And so I have also attached that to the memo. So essentially what the drafting office will be doing is to put together what I forwarded to them, and same will be lifted to Speaker's office for prioritization.
And you talk about the Speaker because of what we heard during the debate on the anti-LGBTQI plus bill on what the threshold is for a private member's bill. At what point does the Speaker approve of this as having met the threshold?
The Speaker, it's my memo. It's been referred to the clerk. The clerk will forward it to Speaker for his advice. But naturally, Speaker will admit it. We have filed other memos amending other Parents Act, so this will not be out of place at all. We have met the criteria. There's a manual that you have to follow. I am well versed in the terms of the manual. We have drafted our bill within the terms of the manual guiding any private member who may want to introduce a bill. So to that extent, my bill is on all fours, so will be approved.
Now, let's go into the proposed amendment. Now, as far as legal education is concerned, how does the removal of the Chief Justice and the other justices of the Supreme Court, as it stands now, we have 4 of them, that's including the Chief Justice on the General Legal Council, how does their removal from the General Legal Council address the problem at hand? And I'm talking specifically legal education.
Yes. I just heard you ask my first deputy speaker to respond to an erroneous impression that Parliament was dictating to the judiciary. And this impression arises from the fact that lots of persons, including even some lawyers, think erroneously that the General Legal Council is an organ of the judiciary. It is not. And so this education has to be offered. The judicial coloration that the General Legal Council has acquired over time is as a result of the heavy presence of senior judges on the council. By statutory stipulations, every 7 Chief Justice is chairman of the General Legal Council. By statutory stipulations, the 4 senior most judges on the Supreme Court are to also serve on the General Legal Council. So at a glance, you have the 5 senior most Supreme Court judges serving on the General Legal Council. That is intimidating enough. Then you have the Attorney General serving on the General Legal Council. Then you have the Dean of the Faculty of Law serving on the General Legal Council. Then you have the SRC President of the Ghana School of Law serving on the General Legal Council. Then you have representations or nominees from the Ghana Bar Association serving on the General Legal Council. Then I think 1 or 2 other persons nominated by the President are also serving on the General Legal Council. So the council becomes, in essence, a playground for the judiciary. And because that is the heavy presence of judges, they try to bring to bear on the activities of the General Legal Council the judicial independent nature of their work. That is why, with all these crises happening, the General Legal Council won't speak to any of the issues. Until today, the Attorney General has also refused to speak to the matters. So a lot of people whose interests are affected by the functions of the General Legal Council are in limbo. So I think that if we decouple the influence of the judiciary from the operations of the General Legal Council, I think it will bring some sense of accountability. That is 1. 2, the reform, as part of the reforms I'm also asking for, is the fact that the functions of the General Legal Council is to promote legal education in this country. What the General Legal Council is presently engaging is killing legal education in this country. Check the number of Ghanaians who are traveling to the Gambia, to Rwanda, to Botswana, to Kenya, to Sierra Leone to get trained as lawyers and come back, and then the General Legal Council will charge them the equivalent of £6,000 for them to do the post-call. This is killing the opportunity for people to get trained as lawyers in this country. So those reforms are going to open up the opportunity for the faculties to be able to train their own products. We are also asking that there should be 1 national bar exams.
Mr. Dafeonto, we'll come to the other ones, but on the specific question of the removal of the Chief Justice and the other justices of the Supreme Court from the council, the council also chiefly regulates the legal profession in the country, and so removing them to promote accountability and also to transparency and promoting legal education, I clearly do not see the link. If you can establish it for us properly, you have said that the justices, because of the way they practice, do not respond to issues in a manner that you would want them to, and that kind of practice has been moved to the General Legal Council, and so you think that removing them will provide the avenue for others to respond to the issues. But how then does it deal with the specific issue at hand, the issues of space, the issues of access?
Now, the General Legal Council is presently building the law school village, or the law village as they call it. Now, for the past 5 years, the project has been slow in taking off. Would it not be proper, for instance, as a forward-looking approach for the General Legal Council to say that we are in need of funds, and yet we don't have adequate space in order to be able to develop and create more space for you? So aside from those who will regularly admit, we should be able to admit others who will be willing to, for instance, pay fees. Imagine that the General Legal Council says that those who are interested in paying full fees, you should be able to come in. They will get the numbers. That is a forward-looking approach. The General Legal Council presently, or through the Board of Legal Education, offers tuition to students using Zoom. So you don't need the large numbers of students to congregate in physical classrooms to be able to deliver law lectures. But with the introduction of all this forward-looking approach to teaching students in the professional school, the General Legal Council is still insisting that they must admit fewer numbers. So we think that the influence of new persons, when the reforms come, will be able to bring some changes in this approach.
And what is the proposal for the new people?
Hold on. Then the issue of discipline. In almost all the Commonwealth jurisdictions or common law jurisdictions, it is lawyers who discipline lawyers. When you go to the legal council or the judicial council in this country, which is the council that governs the activities and the administration of the judiciary in this country, there are disciplinary committees that handle the discipline of judges. Lawyers don't get involved. So why should judges be disciplining lawyers at the General Legal Council level? So as part of the reforms, we want heavy presence of lawyers. So lawyers can discipline their fellow lawyers when they go wrong. And that is another new angle or the novel angle that I'm bringing about as part of the reforms. I was about to mention the fact that we are also asking for the writing of one national bar exam, which could be done twice yearly, so that when you leave the faculty with your LLB and a professional training, you graduate from the faculty, you sit for one national bar exam. When you qualify, you are called to the bar, and your name is entered on the roll of lawyer.
And Mr. Dafianto, you are suggesting that this amendment shall, within 90 days upon coming into effect, the General Legal Council shall then take steps to receive, review and accredit various universities with law faculties to run the professional law course. 90 days, is that good time?
Yes, 90 days is good time, because the crisis we face is one of an urgent nature. We need to carry out this reform so that we can address these matters expeditiously. We don't have time.
Now, whilst we wait for this draft bill to take form and to go through the processes, the issue of the resolution that has been passed by Parliament has been rejected by the Attorney General. I heard the Deputy Speaker of Parliament say the Attorney General will be hauled before the House to explain why this cannot be respected. But the question of what the legal basis is has not really been answered for me. What is your position on this?
There's a legal basis, and I'm sure that the Attorney General glossed over it. Let me refer you to Article 103, Clause 3 of the Constitution. It is very specific. It says that Parliament, through its committees, has the power to inquire into the activities of ministries and departments. And to the extent that even matters of administration, Parliament can inquire into and make directives. Now, here is the thing. If the Minister of Justice is accountable to Parliament, is it not by parity of reasoning feasible to say that through the Minister of Justice, Parliament can direct the General Legal Council as to what to do in terms of performance of its functions. And let me give you another legal basis. The General Legal Council comes to Parliament every year to ask for a certain amount of money to be given to it for purposes of performing its functions, which include promoting legal education, not killing legal education. So if in the view of Parliament in the course of one calendar year, we come to the realization that in the course of performing your functions as a state institution, you are killing, instead of promoting legal education, we have the power to direct. Because it goes to budget performance. What is happening is goes to budget performance. How are you performing in terms of your budgetary allocation?
Very well. Very well. Mr. Roxton Dafiamot, I want to thank you for your time. That's the Member of Parliament for Saddine, Roxton Dafiamot, who has filed a private member's motion to amend part of the law to, among other things, remove the Chief Justice and other Justice of the Supreme Court from the General Legal Council. And also address the issues of legal education in this country. Let's go on to the phone lines again. We're joined by a lawyer, a former Member of Parliament, and former ranking member on the Constitution Legal Affairs Committee of Parliament, Inusuf Hussaini. Mr. Hussaini, thank you for your time here on Top Story. Which of these positions do you lean towards in terms of the resolution passed by Parliament and the response given by the Attorney General?
Well, it's a very difficult question, isn't it? Because Parliament has got oversight jurisdiction over institutions of state to which Parliament allocates resources of state. So this oversight responsibility gives Parliament the opportunity to oversight those institutions in the use of the resources of the state. But the question is, does Parliament have the power to interfere directly with the performance of the functions of those institutions?
What do you think?
I don't think so. Even with the Attorney General's general directives, those general directives are to be related to policy. So the Attorney General may give general policy directives. So, and policy is the preserve of the executive. Lawmaking is the preserve of the legislature. So where the Attorney General gives directives which are not in the nature of policy, the General Legal Council is entitled to refuse.
And so you think that Parliament should just leave this to be?
I think that Parliament should have chosen another route.
Which is?
Of inviting the General Legal Council as part of their oversight responsibility to explain to them the reasons why 499 students were excluded from the admission list as advertised in the earlier advertisement for students or prospective students who wanted to enroll at the law school. Now, you see, when you take a confrontational approach, it does not help bring the issues to the fore. The issue confronting us in Ghana is not the 499 students. The issue confronting us is a Ghana law school that was built in the 1960s to admit students only from the University of Ghana. Now we have more than 10 universities offering programs in law. The University of Ghana, the traditional institution that contributed students to the law school, now trains far more students than can be admitted at the law school. So clearly, we need facilities to be expanded in such a way as to make opportunities available, the opportunity of enrolling into a Ghana law school available to a greater number of students.
But Mr.
That will require resources.
There are some who have argued that this is also beyond the issue of space. It's also about the will, the political will, both on the part of government and the General Legal Council,
to make
sure that this
so
happens.
Parliament, because they have the power of the purse, and they want greater number of students to gain admission into the law school, could direct the executive, that they make resources available because they are going to approve the resources. Parliament is going to approve the resources. And that it is in the view of Parliament that resources be made available to the judiciary intended to expand facilities for admission of law students across the country. And
Mr. Hussaini, we ran out of time on this, but I'm grateful that you could join us with your thoughts here on Top Story. That's former Member of Parliament, Mr. Hussaini, who was also ranking member on the Constitutional and Legal Affairs Committee of Parliament. Newsnight starts now.